Hi, welcome to Property Management Tips with Marcella. This week, I want to talk about what happens if your tenant tells you they want to terminate their lease early. Of course, in all of our leases, most companies will have what happens if you terminate, what the expectations are, and what happens if you terminate early. And like in our case, we also have an addition to our lease agreement, which is called a multi-disclosure. And it also talks about in details what happens if you terminate your lease early. But there's some things to keep in mind. So the basics of terminating a lease. Why would the tenant want to terminate the lease? One of the reasons could be military. If the tenant is deployed or has orders to relocate, that is a valid reason to allow the tenant to be out of their lease. And it is written in the lease agreement, the procedures, which are the tenant to provide their orders, their commanding officer, so that you can do verifications and provide proper notice as well. Then another valid reason, it's domestic violence. Now, in every state, the laws are different. However, it will not be a good practice, or it's not advisable to try to force a tenant to stay in their lease if they're a victim of domestic violence. So consult your attorney on this topic, but I would suggest working with the tenant to let them out of that lease, should this be one of the cases. What about if they lose their job? They obviously qualified to pay the rent for the lease that they signed for, but nobody can predict what happens. And could they have lost their job? And now they no longer have the income to make that rent payment. Is it better for the tenant to go through an eviction process and cost you more in legal fees, or working with the tenant to exit in a good manners and to minimize, if any, loss in income to the landlord? So this is a valid point that, as property managers, we want to find out what happened. What are the possibilities of the tenant recovering their job? Were they transferred? What is the reason that they need to terminate that lease? And consulting with your landlord, weighing out the positives and the negatives in this situation. Is there a divorce or an illness? And again, even though you have a valid contract and a lease, as long as it's signed by both parties representing the landlord and the tenant, it is a binding contract. However, is there an illness? Is there a divorce going on? You have to get a little bit more information before providing the facts to your landlord, but it would be a good idea to work with the tenants and try to allow them to buy out of their lease to minimize the landlord's losses, if any, and also helping the tenant move on with their life. Uninhabitability. Okay, we have to provide a habitable property, and that means working gas, heating, electricity, plumbing, sinks, toilets, showers, no leaking roofs, no hazards such as pests, etc. So legally, we have to have a habitable property. If we cannot provide a habitable property, then that is a valid reason for a tenant to want to exit and move out of their lease. Of course, all of these things don't happen overnight, and this is something that you want to work out the terms. In some cases, you may have to place the tenant in a relocation until that problem is resolved. So evaluate what is the problem that it's making the property uninhabitable, such as your air conditioner, it's out and it will be a week before you can obtain those parts. Maybe providing portable AC units, it's what the tenant would like, or they would rather receive just the rent credit and be staying with the relative while the air conditioner is being fixed, or they rather be placed in a hotel. So evaluate, talk to your tenants and talk to your landlords. What are the solutions that best fit both parties? Something that it's very, or becoming a big problem, at least that I have noticed, it is sometimes property owners do not want to provide the 24-hour notice to enter a property. And we're talking about non-emergencies. Yes, a landlord is the owner of the property. However, the tenant has rights. And as an owner, you cannot violate that right by showing up to the property without giving proper notice and being unannounced. You have to have valid reasons. If it is an emergency, of course, we try to communicate with the tenant, and should we need to enter because the house is on fire for extreme reasons, it makes it different than you, the landlord, came to town and you want to go see your property, so you decide to show up and knock on the door and say, I'm the landlord, I need to enter. That is not a valid reason. Proper notice has to be provided. If the tenant feels unsafe because of constantly trying to enter the property and not respecting the privacy of the tenant, of course, things don't happen overnight. The tenant would have expressed their concern. They can request to terminate the lease for that reason. So it's very important, and that is why all notices have to be served. So yes, 24 hours, but I always say 48 hours, because we have to serve the notice and have proof that it has been served, and then provide the 24 hours to enter once it's served. So a good practice would be to provide 48 hours. Now, keep in mind, people do work, and unless it's an emergency, we cannot expect a tenant not to go to work to enter the property. So it helps if we could all accommodate the landlord's needs and the tenant's needs, and it is a good idea to provide as much time as possible to let the tenant know that the landlord is in town and would like to visit their property. Understanding the early termination negotiations is one of the other very important, and mitigation. Here is my take on this. Yes, we have a binding contract. Once the signatures are in the contract, we're all in contract, and we need to respect those contracts. But a lot of times, trying to figure out what's the reason for trying to break this contract, and trying to work with the parties involved, it's better, because if a tenant wants to break their lease and we can help them, we're going to be able to minimize the cost or loss for the landlord, and at the same time help somebody else out, which is in this case the tenant, and make sure that the property is returned in good conditions. They're also cooperating, allowing to show the property, to find a replacement so that we know who is in the property, do their background checks, instead of forcing them to stay in a lease that, yes, you have the right to do because you have a valid contract, but they may try to sneak in a subleasing so that they can satisfy their responsibility, and we don't want that to happen. We always want to have documentations as to what's going on. That's why it's very important to document maintenance records and always use licensed contractors so that we can have the records that it's not a habitable concern and why a tenant may need to terminate their contract. Not assuming that you automatically get to keep the security deposit. So security deposits are there primarily to make sure that the property is returned in the same conditions that it was given to them, and not necessarily to cover rent, even though it can be applied to some of the balances left by a tenant. But this is something that in each case has to be analyzed. And of course, most of the contracts, and like in our case, there is consequences for early terminations. You may have a fine because you're going to have to pay for for a showing agent to show your property. You're going to have to market the property. So there is expenses involved with finding a new tenant, and let's hope that there is no rent loss. So for those reasons, sometimes you may have early termination fees. And as long as you disclose them in writing up front, like we do in our case, then the tenant is aware of what happens if you terminate your contract early. We always, regardless, unless there was a death, request for a 30-day notice. And we always want to work with both sides, because there's nothing better than communication and trying to minimize loss for either party. There's always the buy down option or buy out option in some cases. If, let's say, the landlord, it's the one requesting to terminate the contract early, maybe because they want to sell their property. Even though as a landlord, you can sell the property with the tenant as long as the contract is honored until the end of that lease. But you may want to offer the tenant an incentive to terminate the contract earlier so that you have a vacant property by the time you close of escrow. So it depends what the motives are. Communication is the key. Let's see, what else is it very important? I think the most important part about early terminations is recognizing that it is a valid contract. And that is why I personally don't like to do month to month. And here it's my take on that. Number one, if you're a tenant, I would suggest not doing a month-to-month contract. Why? Because as long as you have a valid contract, your contract should be honored. Whether the property is sold and there is a new landlord, you have a valid contract. And until that contract ends, as long as you satisfy your side of the contract, then you're safe. If you are in a month-to-month situation, then it really only requires a 30-day notice to ask you to vacate. So that is why I don't like month-to-month contracts. As a landlord, if you are planning your year worth of money coming in so that you can plan of your maintenance repairs and your income, then it's a good idea to be on yearly contracts and not just do month to month for the same reason. Because if you're on a month to month contract, all it takes is a 30-day notice to terminate that contract. And otherwise, if you have a lease and it's renewed every year, then it provides more stability for you, the landlord. So yes, early terminations can be done. The key points are why. What's the request? Whether it's the landlord requesting it or the tenant, what is the reason? And what can we do to satisfy both sides of the transaction and at the same time minimize the loss or the cost for the landlord and or for the tenant? Hope this helps. And remember, if you have any other questions, call me at Monarch Property Management, LasVegasYourHome.com, 702-412-7189.